next case to come before the court is Daniel Delfino et al. Versus Summit County et al. Good morning. Is counsel ready to proceed? Okay. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of time, and I'll try to alert you when you're heading into your rebuttal time. The arguments are being recorded, so please come up to the podium, introduce yourselves, stay behind the podiums, keep your voice up. And you should not use the name of children or minors or victims should that be relevant to your argument. I don't think it is here, but you can refer to those folks should that arise with their initials or generic terms. We've read your briefs and we're ready to proceed when you are, and I would just ask appellant, would you like to reserve time?
Yes, Your Honor, 5 minutes for rebuttal, please.
Very well, then you may proceed when you're ready to go.
Good morning, Your Honors. May it please the Court. My name is Tony Vicanti, and I'm legal counsel for the appellants in this case, Dan and Mindy Delfino. This case is about the responsibility of quasi-judicial bodies and of courts, especially when dealing with constitutionally protected property rights, to properly apply the correct legal standards set forth in the local ordinance and properly weigh the evidence before that quasi-judicial body. The Ohio Supreme Court in Nord v. Horney has indicated that private property rights are strongly protected in Ohio and must not be trod upon lightly, no matter how great the weight of other forces. In that case, the Supreme Court directed lower courts, like this court and the trial court, to scrutinize governmental decisions relating to real property because they are such constitutionally protected property rights. Here, the Planning Commission trotted on my client's constitutionally protected property rights by refusing to allow the Delfinos to use their vacant property by denying the variance. In addition, the trial court trotted...
You say that it refused to allow them to use it, but there is some notion in the brief that the Delfinos wanted to build a 4,000 square foot ranch.
Correct.
Is there any evidence that there could have been an alternative?
The testimony by Mr. Delfino's engineer, Mr. Neff, who's a professional engineer, said because 82% of this property fell within setbacks, and because of the front yard setback, it only allows developability of the property for 30 feet, so it was not buildable without a variance.
No structure?
Correct. That's what Mr. Neff testified before the Planning Commission.
And was there any other testimony on that point?
There was not. There was not, Your Honor. So basically we're here for two reasons why the trial court and Planning Commission's decision should be reversed. First, the Planning Commission clearly lost its way as a matter of law and failed to apply the correct criteria and standards to the evidence presented before it. Second, the trial court abused its discretion by affirming the Planning Commission's decision, which was not supported by a preponderance of reliable, probative, and substantial evidence as required under Ohio law. I'll rely on the briefs for most of the facts, but happy to discuss any of the facts as we have already. And I will move forward to the first reason why this court should reverse the trial court. The Planning Commission clearly lost its way by applying the wrong legal standard for repairing setbacks, and the trial court erred as a matter of law by simply assuming the Planning Commission did so. The standard of review on this issue is de novo because it does entertain a matter of law as to the correct legal criteria to be applied. There are three factors set forth in Summit County's ordinances, set forth in section 937.10F. These three factors, the Planning Commission shall, it's obligatory, review these three factors and render a decision based on the testimony before it as to whether riparian variances should be granted. Those three factors are: one, the extent which the requested variance impairs the functionality of the riparian setback; two, the soil natural vegetation and whether the property sits in the 100-year floodplain. And 3, the burden and the degree of hardship on the property owner and whether alternatives exist. The Planning Commission just had a broad discussion. The Planning Commission never referenced any one of those standards or never even referenced Section 937.10F. The planning staff member, Mr. Steve Nill, when presenting this application, indicated that the planning staff would defer to Summit County Soil and Water because they're the experts, and so they recommend following whatever Soil and Water recommends. Mr. McKenzie of Summit Soil and Water testified that because the variance encroaches onto the setback, his hands are tied, quote unquote, and that they must recommend denial. Did not take into the fact that variance exists for a reason, and any variance is going to encroach into that riparian setback. The Planning Commission, on a motion to deny my client's application, expressly said they moved to go with the staff and Soil and Water Conservation District recommendations to disapprove of the project. That being said, the trial court in its decision indicated that there was no evidence that the Planning Commission took to heart Mr. McKenzie's recommendation. That directly conflicts. Judge Lanzera, did you have a question? Oh, sorry, I misread that, my apologies. So that's clearly an error. The trial court never referenced any of these standards. We're dealing with fundamental constitutionally protected property rights. My client testified and he had his engineer testify. So on that basis, as a matter of law, my client respectfully requests that this court reverse the trial court and grant the variances. The second reason why the trial court should be reversed is that the trial court affirmed the Planning Commission's decision, which was not supported by the requisite quantum of evidence. Basically, it wasn't supported by a preponderance of reliable, substantial, and probative evidence. This is assuming the trial court even considered these factors, which it didn't, as I said. So instead, the trial court came in and reviewed the factors for the trial court. This review is an abuse of discretion review. So meanwhile, this court is just a look at the trial court's application of the law to the facts to determine whether there was a requisite amount of evidence to show that. The first factor deals with the impact on the functionality of the riparian setback. The reasons for riparian setbacks are set forth in Summit County's codified ordinances, namely section 937.01 and 937.040. And basically, the whole point of a riparian setback is to mitigate against erosion, stabilize banks, and reduce floods. All right, those are the reasons. There was no testimony as to how this variance would detrimentally impact those functions. Instead, all the testimony supported that these issues will not be impacted at all. Summit Soil and Water, Mr. McKenzie himself indicated that he doesn't have concerns over meandering streams because there are wetlands on this property and the vegetation in the wetlands, so he's not concerned about that. He also indicated that this property is not in a flood zone, so did the wetlands delineation report that the county required my client submit. They said there was no issue with that. The township also indicated there was no history of flooding with this property. Mr. Neff, my client's engineer, testified as to the additional protections like a silt fence and a filter sock to reduce the amount of any type of sediment and that it should not be a problem. All right? And finally, Mr. Neff testified that, hey, there are no wetlands going to be disturbed and 82% of the riparian corridor on this property will be preserved. The only thing cited by the trial court in support of this is that a planning commission member noted that the house doesn't encroach, but the grading does. But again, that's why my client was seeking a variance. There was no testimony that it would have a detrimental impact on the functionality of the riparian setback.
But the argument at the trial level was they didn't use the right standard. So wasn't she just pointing out in the entry that they were considering those standards?
She did assume that the planning commission, you're right, Judge Lanzier, the trial court judge did assume for the planning commission that they considered the standard, even though there's no evidence in the record. The trial court then assumed that because a planning commission member made a comment that there is encroachment into the riparian setback, that impairs the functionality. There was no testimony that impairs the functionality. It's common sense, yes, we are encroaching into the setback because we're seeking a variance as we're entitled to under Ohio law.
Because you were saying you're making two arguments, the competent credible evidence doesn't support,
Correct.
and they use the wrong standard.
Precisely. The first and second reasons. With regards to the second factor, dealing with the floodplain, the vegetation, and the soil types, again, Planning Commission didn't consider any of this. The trial court even recognized this, but said there was discussion over floodplain, and it wasn't in a floodplain, all right? If you actually look at the transcript of evidence, Summit County Soil and Water indicated that the wetland vegetation protects against erosion. That's what Mr. McKenzie said. Mr. Neff, the engineer, testified that he went to the site and reviewed the vegetation, did not have any issues with the vegetation. The wetlands report submitted indicated that this property was not in the floodplain. Compare that evidence to basically no evidence talking about how this is in a floodplain, or that the vegetation's bad, or that the soil conditions are wrong. Clearly this was an abuse of discretion as with regards to factor 2. And then finally, the third factor is the degree of burden on my client and whether alternatives were available. The testimony, well, let me back up. The trial court, again, replaced its decision for the Planning Commission because there was no evidence in the record of the Planning Commission. What the trial court pointed out as evidence of a lack of burden was that the county engineer's representative just indicated that this is not a good lot for the house.
And counsel, I do want to let you know you're moving into your rebuttal time.
Okay, thank you, Your Honors. And I will wrap up and save the rest for rebuttal. But the remaining evidence by Mr. Neff, the staff report, Mr. Delfino, indicated this property was unbuildable. Mr. Delfino purchased the property without knowledge of this. It was a pre-platted lot that didn't identify, approved by the county, that didn't identify the riparian setbacks, and that the lot was basically unbuildable. So for those two reasons, the appellants respectfully request that this court reverse the trial court. Thank you.
Good morning, Your Honors. John Golonsky for the appellee, Summit County Planning Commission. I kind of want to first start out with a little bit of background. It is in the record. So there were actually two hearings before the Planning Commission. There was two sets of plans presented to the Planning Commission. And I want to point out first that the second set of plans did not even provide for septic. So could the Planning Commission approve something when there was no septic? Septic would affect the setback. And counsel in his reply brief says, well, we really can't consider that we don't know, that wasn't raised. Well, I think if you look at our standard of review, you can consider anything in the record. This is a decision of the Planning Commission. They kind of sit like jurors. There's one attorney on the Planning Commission. They have the law provided, which is correct, I agree. Under 937, under our home rule, we have a standard. That's a standard we're going to apply. And information is presented to them. Evidence. There's some statement there was no technical evidence presented. Well, we had the engineer's office there. 937 says you got to talk to the engineer. They provide technical evidence. We had Summit Soil and Water there. They provide technical evidence. We did not have the health department there. Well, that's interesting. They're not there. They didn't have a septic to review. So I think you could look at the whole record if you try to find whatever reasons, and there are many, why this particular application should be denied. Judge Lanzinger made a great point. This is a big house. That was one of the reasons I think that the Planning Commission had some concerns. It's a big footprint. Yeah, there's a remedy. Build a smaller house. Build a house that's smaller. You might not be able to build a house that's 60 yards, but you could certainly build a smaller house. It might not be the house that the Delfinos wanted, and they might be able to build that house somewhere else. They might be able to build a smaller house in this lot, but we also have to consider what's the message, what's the authority, and why do we have a planning commission? Because we have to control what happens. What happens on one lot can have effects on another lot. The riparian setback, present flooding, present erosion. These are important concepts. So what somebody does on one property isn't just affecting their property. If you put something in a stream, it's going to go downstream. If you do something on this property, it's going to go down. Now there was some representation as well made. Well, they didn't know anything about this. Well, we put it in the brief, and the record is that when this subdivision was recorded, the 937 already existed. It was April 29, 2002 when this 937 went into effect. I believe the subdivision was recorded in July of 2002, and 19 years later, the Delfinos purchased the property. They purchased the property. 937 is a code. It's in, anyone could assess that. There was also some statements in the brief. Well, there were some other properties that encroached on the riparian, but there's no evidence as to whether they were granted variances. There have been some 937 changes. Now it's a 10% variance, I believe, which would apply to the Delfinos. I think they saw it 30 feet into the 50, which is a 60% variance. So without knowing specifically why those other properties received variances, it's not really relevant to this discussion that we had this morning. And as far as the three factors, to get just kind of drill down to that. The first factor deals with how does the variance impair the functions of the riparian area. So the chair did speak. He said the house, the building, the 60-foot structure, 60-yard structure, just goes a little bit onto the riparian, but you're going to have to do grading. It's a massive structure. You're going to have to grade into the riparian area. That's going to take vegetation away. What do we want? We want vegetation. What does vegetation do? Absorbs water. So that was actually testified to. I think the engineer, Mr. Paradise, who is an expert, if we were in a court of law, he'd be qualified as an expert, said that is some concerns. In fact, Mr. Paradise's statement said filling in wetlands, filling in the waterway where it can be stored is counterproductive to what we try to do with land management. One of the biggest issues we have at the county, when people come to county council, is stormwater, flooding. So we're trying to remedy that by a land use planning. The second standard, soil and natural vegetation, that was discussed. It didn't seem to be a problem. They discussed it. Another thing I think it's important, the three factors, one is not weighted more than the other. You got to consider all these three factors. But what we decide once we consider those three factors would have to be overturned because it's unconstitutional, illegal, arbitrary, capricious, unreasonable, unsupportable. That's some big words there. And I think if we look at what actually occurred, there's a lot to support why the Planning Commission denied this application. It doesn't mean the Delfinos couldn't come back with another application. Their property hasn't been taken. This particular plan, which was didn't even have septic on it, was denied. And finally, the hardship. So as to the hardship, that was also addressed. I'm going to use Mr. Paradise again, from the Summit County Engineer's Office. This is a massive home from the outside of the driveway to the far end. It's 60 yards. It's not a good house for this lot. It might be a good house, but it's just not a good house for this lot. So I think when we look at what actually occurred before the Planning Commission, there was evidence presented, and there was some no evidence presented. I think if we look, the Planning Commission has to weigh the credibility. So the Delfino's expert presented plans that didn't even have a septic on it. So perhaps the Planning Commission disregarded everything that was part of that plan, because that seemed to be a basic structure of what we need to have, septic. Open to any questions.
Council, on the issue of hardship on that third factor, was there anything else that was presented beyond Mr. Paradise testified this is a buildable lot for a two-story home? It's not a good lot for this house? Or was that
No,
the sum
that was a
total of
sum
that?
total, and I don't think there was, besides what council said, Mr. Knapp, there wasn't really, well, this is, the lot, it was related to this house being on this lot. The hardship would be you couldn't build anything. I think that's what the assertion is. You can't build anything. You could build something, just something that's small. So I guess the question would be, if I have to build a smaller house, is that an undue hardship?
Was there any testimony about needing a ranch, like not having stairs or disability?
No.
Or
Not to my knowledge.
And if I'm not mistaken, I might be mistaken, so correct me, but I believe that opposing counsel mentioned that only 30 feet would have been allowed for building of the home. Is that consistent with your understanding?
I think it's where you put it on the property, so we didn't even know where the septic was gonna go, so I think it's hard to make that assessment. So without all the factors, I'm not gonna concede that he's correct.
Very good. Fair enough. Any further questions? Hearing none, we thank you very much for your presentation. Council?
Thank you, Your Honors. I just want to address a handful of items pretty briefly here. We'll start with the last comment made that a smaller house could go on this property. Mr. Neff testified that a smaller house could not. Mr. Paradise with the Summit County Engineer's Office was mistaken. We weren't filling in wetlands. He clearly did not know what was going on. He did not conduct a study or anything with regards to the site. He had to be corrected that we weren't even filling in wetlands. So unsubstantiated opinions have very low probative value or weight. You know, he hadn't been qualified as an expert or anything like that. There was, Judge Lanziger, there was testimony with regards to Mr. Delfino and Mr. Neff talked about how Mr. Delfino wanted a ranch because this is their retirement home and they wanted an age in place. So that's why stairs, you know, were not appropriate, and a two-story home would not be appropriate on this lot. Counsel for appellees mentioned that there were two sets of plans. He is correct. The second set of plans presented to the Planning Commission showed a reduced variance. We moved the house even further out. There is testimony in the record, it's cited in the brief, it's page 21 of the written transcript, where Mr. Neff indicated, we've moved the septic outside of the riparian setback, it will not be in the riparian setback. And it was confirmed with the Planning Commission. That was not one of the factors the Planning Commission would have to review. We would have had to go through Summit County Health District anyway for a separate approval. So, you know, the fact that septic wasn't shown on it, the only evidence says that it will not be placed in the riparian setback, and that's clear in the record. Counsel for appellees mentioned that there was technical testimony from the engineer in soil and water. Again, the only testimony is that this will encroach, the grading will encroach. It did not address if it's going to impact the functionality, which is the actual standard. The devil's in the details, especially when you're dealing with constitutionally protected property rights. Counsel for appellees mentions that what happens on one property happens on all, and therefore there might be debris spewing into this waterway. It is in the record that 7 properties already encroach in this neighborhood onto this riparian corridor, and there aren't any issues. First of all. Second of all, there's no evidence that the debris was going to be going into the waterway. As a matter of fact, the only evidence on the record was that protections, the vegetation that's going to exist in the wetlands will protect the waterway, and the engineer testified about the silt fence and the filter that's going to be placed in to completely limit the debris. There's no evidence on the record that debris is going to be flowing into the property. With regards to the 10% variance, that's, first of all, it's waived. It wasn't raised before the Planning Commission. Anything not waived or raised is waived. Second of all, that's a misstatement. With all due respect, that applies to subdivision approvals. It does not apply to individual lot approvals under the express language of the Summit County ordinances. So again, the devil's in the detail, especially when you're dealing with these constitutionally protected property rights. So for the foregoing reasons and all the reasons in the brief, appellants respectfully request that this court scrutinize the decision below, giving due deference, and scrutinize the Planning Commission's treatment of my client's private property, and reverse the trial court on 2 reasons. One, both the Planning Commission and the trial court failed to properly apply the correct standards. And 2, the Planning Commission's decision was not supported by a preponderance of probative, reliable, and substantive evidence. My clients just would like to retire and age in their single-family residence. Appreciate this board's consideration and time on this important matter for my client. Thank you.
Thank you for your presentation. Thank you both for your arguments. The court will take the matter under advisement and issue a decision in due course. You will receive a copy of that decision from the clerk of courts that will be mailed out to you on the day that it is released. And the opinions will also be posted on the Ohio Supreme Court website. Thank you both again.
All right. Thank you. Have a great day.